The race to replace retired Chief Justice David Maraga is gaining momentum, with the Judicial Service Commission embarking on interviewing the 10 shortlisted candidates. A public display of legal wits, jurisprudence, legal philosophy, and administrative capabilities is set to get the country its third Chief Justice under the new Constitution. Tonight on Pundits Night, our eyes are on the corridors of justice. Good evening and welcome. As always, your voice matters, so does your opinion counts. Keep talking to us. The hashtag to use is Pundits Night. Send us a message on 22047. Be part of this discussion. Our guest tonight is lawyer Dunstan Omari. Wakili, good evening, and thank you for making time for us on the county's television tonight.
Thank you very much, and viewers of TV 47. We are doing serious stuff.
All right, Wakili, Kenya's 2010 Constitution in Article 171 talks of the establishment of the Judicial Service Commission. It in great length talks about the composition of that commission. And it says in part, and I quote, that the Chief Justice who shall be the chairperson of the commission. Given what we saw today, a scenario where the Chief Justice was part of the commission and the commissioners present, but the commission was led by the deputy, the vice chairperson, are there any legal consequences to that?
Thank you very much. Viewers, what happened is that there is no substantive Chief Justice who is supposed to be the president of the Supreme Court and the chair, the substantive chair of the JSC. Therefore, Deputy Chief Justice Maraga never assumed the substantive position as the chair of JSC. Once there is no substantive chair of the JSC, the members of the JSC that are present will nominate one of themselves to be the chair. That is standard practice in all board meetings, in all panels, and in all JSC, and the best practice worldwide. Therefore, there was nothing wrong about that positioning. But also remember, there are political undertones to this position of the Chief Justice. People filed petitions in court to challenge the DCJ from sitting in that panel. Letters have been filed, for example, by my senior counsel Murgol for DCJ Mwilu to recuse herself from the sitting. The JSC met and gave a clarification yesterday that DCJ Mwilu will be sitting as a member of the JSC.
All right, so Wakili, we will come to that. We will come to that. And the former DPP was citing cases of conflict of interest, given that the Chief Justice, one of the applicants, acted in court for the acting Chief Justice. But is it not the assumption that the acting Chief Justice, in the absence of a substantive Chief Justice, is the president of the judiciary for that period of time?
The JSC must have sat and looked at the politics if she chaired that work. What we know for sure is that today the chair was Professor Olive Mugenda. Who will be the chair tomorrow? Nobody knows. They might have agreed that they give positions of chairs rotational. Two, there is nothing wrong, perception-wise. If Mwilu sat, probably it could have complicated the situation. And therefore, in taking a bit abundance of caution, they decided that let Professor Mugenda sit. Remember, there is also a petition in court challenging Professor Mugenda's position. She is alleged to be the chair of the board of Kenyatta University Hospital. So both the sitting chair today and the DCJ have litigations against them. Is litigation a reason to stop anybody from executing their mandate? No, unless there is a court order. And therefore, as far as the JSC is concerned, and as far as I'm concerned, there is no order from the court saying that DCJ Mwilu nor Olive Mgenda will not sit as the chair of the JSC.
All right, Wakili, we are talking of the position of the Chief Justice, which to many is the pinnacle of a career's ecstasy. Why have Kenya's top judges who are currently sitting at the Supreme Court, plus the acting Chief Justice, in your view, shunned, forgone this position, applying even, showing interest?
There are three fundamental reasons. Nobody stopped those judges because they're very qualified to apply for the job. But those judges must have looked at three parameters and decided not to apply. One, their age. They are young judges. Are they likely to apply and they be disqualified from getting the position because of their age? Two, those judges have expertise. They have seen what the challenges the two chief justices have faced. People like Smokin Wanjala, professor, was with Mutunga. He saw the tribulations Mutunga faced. They are alive to the reality of what has happened to Justice Maraga. Therefore, people have said they have seen how their DCJ has been dragged all over to court and to every other criminal sanction. So they have decided either one, they will only apply after the exit of President Uhuru's tenure, and that must have formed their decision for them not to be exposed. One, if they are not for the system, they might have been scared that the KRA, the DCI, the ESCC, and all other investigative arms of government might have been unleashed on them. So they said, to be on the safe side, let us observe, we will apply in the next presidential regime. So that is the second point. The third point, I think, is that they looked at the seniority of the judges who are going to apply, both from the judiciary, those advocates who will apply from outside, those professors who will apply from outside, and the judiciary. In terms of seniority of the law, legal practice respects seniority so much. Can they become chief justices and be in charge of very old senior judges? Probably those are the three reasons. But let it go on record that there was no any law barring them to apply for that position.
And if these are some of the country's legal heavyweights, Wakili, who are avoiding this position, does that water down the position itself?
The position of the CJ does not get watered by who has applied. The position of the CJ is a protected position. It is a position of glamour. It is a position that is the apex of anybody who went to a law school and studied law. It's a dream for every lawyer. We are now around 21,000 lawyers in this country. Every single advocate, every single judicial officer, every single state officer in the DPP's office and all positions dreams of that position. Therefore, it does not lower the position of who will sit on that position. The mandate and the legal positioning is very clear. In fact, whoever comes in becomes more glamorous as a third Chief Justice under the new Kenyan Constitution of 2010.
And Wakili, what shoes does the incoming Chief Justice have to fill?
Before 2010 Constitution, judiciary was as a department within the executive. The president had powers to appoint, citizens had no role. The Judicial Service Commission had no role. Under the new and the independence of the judiciary was totally destroyed. Remember, at one time, the independence of the judges and the tenure of the judiciary had been removed. So they were clerks working under the mercy of the president. They were serving at the mercy of the president. Come the constitution that we have in 2010, the security of tenure, the independence of the judiciary came in. And from 2010, under the under the tutelage of Chief Justice retired, the Chief Justice retired, we have seen serious development of jurisprudence and the development of administrative independence under Mutunga. When Maraga came in, he enhanced and made the judiciary more visible, and the position of the CJ was defined. The mandate of the Judicial Service Commission was defined. The mandate and powers of the CJ was defined. So whoever is coming will have to blend Mutunga's activism and pro-poor approaches and Maraga's stickler to the rule of law. And we need now somebody who will blend that and bring in another two dimensions so that every new CJ brings something as a legacy, because we...
Outsider from the bench and insider from the bench. Is it time to flip the coin again?
Yeah, we are seeing when we bring different people from different sectors, they bring in and enrich the history, and also they bring in new ways of doing things. Mutunga brought the activism, the donor funds. He brought about the human rights aspect. He brought about the humanity of the judiciary. Remember, he removed the red gowns. He removed the scaring wigs. He brought the judiciary to Mathare. People believed in Mutunga, and you could see the huge cases that were being filed. Even if the backlog was being fought, there was a serious confidence within the Kenyans about the judiciary. Come Chief Justice Maraga, we saw the apex of the confidence of citizens in the judiciary. We saw a judiciary that is ready to take the bull by its horns. We saw the judiciary that is ready to tell the president, not anymore. We saw the judiciary that is telling the legislature, because you have failed to comply with the Constitution of 2010, you should be going home. So what we were two brands. One, Maraga came from private practice and came to be the judiciary. Mutunga came from the political activist, from the university as a lecturer, as a political detainee, and an activist within the civil society, and lastly, as a former detainee to lead the judiciary. We now need either somebody also from outside, either the academia or purely from practice, so that we now have an advocate taking that position. Because the reason that we will be pushing for an advocate is because the litigants, the consumers of the judiciary system are not the judges. The judges are the ones who Kenyans perceive to be the reason why they are facing their problems. Why their cases...
Wakili, let me interject you at that point. You say, you talk of Maraga's tenure witnessing boldness in as far as the judiciary is concerned. But that boldness surely came with an expense, a cost attached to it. It came with the lack of respect for court orders by the executive. It came with the president failing and refusing to appoint the judges whose names were submitted to him. It came with what judges say were clear intimidations and revisiting. That boldness came with consequences, did it not?
The consequences are very temporal. The executive is a government that is formed for 5 years. It will not be there. Remember, any time you disobey a court order, an application for contempt of a court order has no time limitation. If President Uhuru Kenyatta and William Ruto and now Raila Odinga have opted to the rule of impunity, to the rule where they have decided to disobey the court orders, they themselves have come to be the law. It is very clear that after the term of you cannot sue the president while he's serving. But the law and the Constitution of Kenya says after he leaves office, any criminal and civil proceedings will start. The officers who have defied court orders, the cabinet officers who have defied court orders, the PSS who have failed to comply with court orders, let them be alert, and they are watching TV 47, that we will be moving to court upon their protection, their insurance, their umbrella being the president, his exit. Kenyans will be going to court to pursue the rule of law. So Maraga's
Wakili, let me ask you this, still on court orders. The executive and many of those who have rubbished court orders claim that the courts are quick in giving orders, even on things that do not necessarily need an injunction from the courts. You don't buy that as a lawyer?
Tell them this. They could have gone to do law so that they become judges. They do not have the capacity, training, or skill to interpret a court order. Their role is different because the judiciary cannot purport to do what the executive is supposed to do. Maraga told them very clearly, if the judiciary is a burden, go to the referendum, because it is not them who created the independence of the judiciary. It is Wanjiko through the constitution and through the referendum. If they feel aggrieved, let them amend the constitution, let them go to parliament, make laws, but the validity of those laws are subject to the constitution.
But Wakili, what the executive has cited is that a judiciary that is puncturing the progress of what it intends to do as an executive.
We agree. What you'll tell them, if they are not listening, tell them tomorrow that they must do what they want to do. All their programs must comply with the law. It is not, this is a democracy. In the preamble we said, Kenya is a democracy to be governed by democratic ideals, to be governed by the rule of law, to be governed by the constitution of this country. Anything outside the constitution, remember those claiming like that, they have their powers created and donated to them through the constitution. Therefore, anybody appearing to challenge the constitution, in Article 3 of the constitution, it is very clear, you cannot challenge the validity of a constitution, you cannot take this constitution to court, and therefore they should be advised. Even a first-year student of law can advise them that their roles are defined, their duties and their mandate are defined. If they have a dispute, they go back to court, challenge that decision. That is why it is only the judiciary that has 4 layers, a magistrate, a high court, a court of appeal, and the Supreme Court. And if they are not dissatisfied, like Mother Karua, they go to the East African Court of Justice. If they are still not dissatisfied, there are other international courts. But making a decision that you will disobey a court order, that is a recipe for chaos. Give them they select which court orders to obey. If Kenyans also say they have announced the curfew, Kenyans refuse to obey that curfew, will we have a country?
All right, Wakili, I want us to move from the independence of the judiciary, but one final question. If then court orders are not obeyed to the latter as they should, is this a case of a constitution without constitutionalism, as some say?
It is a constitution without constitutionalism only for the executive. For the citizens, they know their constitution has constitutionalism. They are only lucky that they will not be contesting in 2022. Kenyans will recall them. But the aspect of constitutionalism, I've said, it is just a time bomb. They will have to be put to court. They will have to be put to account, even when they have moved out of power. We have seen President Zuma. We have seen quite a number of people who tried to subvert the law. Now they are facing the courts. You can only avoid the courts if you decide to disappear to Langata Cemetery. But if you are alive, that contempt of court, unless part, remains in the record of the court files.
All right, Wakili, let's talk of corruption in the judiciary. The exiting Chief Justice, who is now retired and former Chief Justice, will be remembered partly as well for being a staunch SDA Christian who, in his interviews, when he was being interviewed by the Judicial Service Commission 10 years ago, swore by the Bible, saying that he never received any bribe, hence he does not fancy corruption. Has that religiously obedient Chief Justice failed to nail corruption in the judiciary?
Well, the investigating arms of corruption are in the hands of the executive.
Mm-hmm.
The judiciary does not have the police. They don't have the DCI. They don't have the
Wakili, I'm talking of corruption in the judiciary.
That's the direction I'm going.
Mm-hmm.
The judiciary cannot investigate itself because it does not have the skills. It does not have the capacity. The arms, the Constitution vests the powers of investigation in the police, in the DCI,
mm-hmm.
in the EACC.
Mm-hmm.
Maraga and his group, the JC, can only deal with allegations against judges that are disciplinary in nature.
Mm-hmm.
Criminal issue, corruption is a criminal question. It is the role of the DCI, it is the role of the EACC to investigate, to arrest, and charge judicial officers.
Mm-hmm.
Have they done that? They have not done that.
Mm-hmm.
So let us agree that the media cannot be blamed for corruption,
mm-hmm.
because we invest billions of money. We have created independent offices
mm-hmm.
to deal with that. What have they done? They have done nothing. So let us not blame the judiciary when the constitution in Wanjiku does not give them the power to investigate, to arrest, to charge, or to do anything. If they arrest a magistrate,
mm-hmm.
definitely Maraga or any other judge who will be the Chief Justice will interdict as provided for under Section 62 of the Ethics and Anti-Corruption Act. So let the executive not push that narrative that the judiciary has failed.
Wakili, it's not the executive that is pushing that narrative. It is observers, Kenyans, and in fact other organizations and institutions like the media. And that's why I'm asking you this question. And I'm sure you must have heard of the cliche of why hire a lawyer if you can bribe a judge.
And that is why today this TV 47
mm-hmm.
is being watched by over 40 million people,
mm-hmm.
because today I'm putting it very clearly
mm-hmm.
that glitch, the only person who can solve that perception and that glitch is the EACC, the DCI.
Mm-hmm.
Two, the perception Kenyans you have, get it very clear, you never gave the judiciary the power to investigate. You gave the DCI, you gave the Inspector General, you gave the EACC, you gave those agencies those powers, you gave KRA to do that job. Do not start apportioning powers not granted the judiciary, unless in the BBI or unless in the new constitution, let us and say the judiciary has police powers to investigate. If we do that, it will not go anywhere, because worldwide, the role of investigations, arrest and prosecution is the executive.
All right, but Wakili, as the chief custodian and the chief interpreter of the law, it's at best the basics to expect that this institution will be corruption-free at an ideal level.
What we know, the principles of jurisprudence and decision-making is that the courts and the public should have certainty of decisions.
Mm-hmm.
So that it's very predictable. On this offense, other decided cases of similar fact, that is the decision. In the history of all courts and judiciary worldwide,
mm-hmm.
that is what I said, the independence of a judicial officer
mm-hmm.
cannot be influenced by anybody. And because of that, the world and best practices 4 layers were created. A magistrate, a high court judge, a court of appeal judge, and a supreme court judge. So that if you think your decision was not right, move to the next court. And that is the reason. Those are the checks and balances of those decisions. If a magistrate was corrupted, why don't you go to the high court and the high court reverse that decision? If the high court judge, according to perception, was corrupted, go to the court of appeal. Why do people want to demolish an institution called judiciary? Yet the avenues of recourse are 4 plus international avenues. So my position, and that's why I say today every Kenyan is watching this program on TV 47, is that today you have learned that stop saying that this decision was out of corruption. Move to the next court and file an application there. If your case has merit, you'll get the right decision, and that decision that you are challenging will be vacated.
Wakili, I still insist on this question of corruption in the judiciary, because you will expect a corrupt person who, for instance, stole public money somewhere will be taken after investigation to the court of law. If those court of laws, more than just a perception, in reality themselves have dints of corruption, it's surely 1 minus 1.
I'll tell you for free, I run and I defend very many corruption matters. I run and defend very many murder trials. I am per se mostly a criminal lawyer and a family lawyer. I will tell you, the judge will only decide a case based on the evidence produced. If the evidence was cooked at the police station, don't expect the judge to convict anybody. If the evidence has gaps, if the prosecution is not alert and aware of the case they are bringing to court, as advocates, as alligators, as crocodiles, we will demolish the evidence of the state. The judge and the magistrate only listens. He will convict based on if that evidence stood the cross-examination from 10, 15 top lawyers. So it is not about the judiciary. It's about how do we as a country reinforce the DPP to have serious prosecutors who are senior and who are paid salaries very well. How do we get police officers? You saw the other day when the CS for Interior was saying we need to employ graduates, police officers. The police insisted they will not be able to retain them. They want to employ from 4 levers with the D. How do you expect that guy to stand against me in court? How do you expect him to investigate a serious corruption matter? So it is us to put more emphasis and fund our institutions, then we'll get results in court.
All right. In the 5-hour interview today of the first applicant among the 10 shortlisted members, the commission was very specific on, among other areas, the transformational agenda of the applicants in as far as the judiciary is concerned. First, as a lawyer, what does that entail? What does transforming the judiciary entail in your own view, Dunstan?
Our view is not my own view, it's the view of every lawyer. I have said that before 2010, the judiciary was a mere department under the executive. It used to get calls and do what they used to do. Number 2, the old judiciary was not sensitive to the consumers of justice. The old judiciary had a serious problem in perception and in reality. Justice retired Mutunga came in and said, we need to chart a new transformation from the old to the new. A serious document called the Judicial Transformation book and policy was drafted. Every stakeholder was involved. We developed it the way Kibaki developed the Vision 2030. That is the roadmap, the blueprint that must be followed. That document talks of more than 30 years of how the judiciary should move Therefore, the JC was very categorical that we need a judge, a chief justice who understands the issue of transformation. A court that is pro-people, not a court against the citizens. So that is why, and to me, that is the only salvation of this court. So long as the legislature funds that transformation, so long as the executive provides funds from treasury to achieve that, we will make noise. We will make noise. If that blueprint is not funded, then, and there is political will, we will only be having talk shows on TV.
All right, and finally, let's talk of the fences that some say need to be mended between the executive and the judiciary. Of course, two arms of the government that are at loggerheads. There are fallouts very evident in as far as Maraga's tenure and President Uhuru Kenyatta's regime is concerned. What will that mending of fences entail? Will it be one arm humbling itself?
I listened to Justice Chitembwe, who was being interviewed today, and he was very apologetic that he will want to negotiate. He will want to give in. You cannot give in a position, for example, on the appointment of 41 judges. You can't say, let the president appoint those two he wants, then we negotiate on the others. You must follow the constitution. You are sworn as a chief justice to defend the constitution. Michuki stood firm when he brought the transport rules. Kenyans were mad, but within a very short time, they saw the benefits of that. The CS Matiang'i, when he went to the Minister of Education, everybody resented. Today we are celebrating. If we get an apologist as a chief justice, a person who cannot push the transformation agenda, a person who cannot defend the judiciary, then we will take the judiciary to where it was. Let us suffer for a very short time. Let us get prosperity. The American Constitution, the American democracy is over 270 years. You cannot make headway to people who are used to having impunity. All of a sudden they agree that the judiciary is making decisions.
You say, Wakil, let me ask you this. You say he was apologetic. There are those who say he was realistic in saying that the president is the one who appoints the judges. That's why the ones who are forwarded the names to are yet to be appointed.
He was realistic. Judiciary has no business being realistic when it is the question of compromising the constitution. He will only need to go to the citizens and ask them, are we amending this? Yes. Or else, if he is going to be realistic, then he becomes the rule of a person. That is why, my friend Kenyans, listen to me. The Constitution is a serious document that cannot be negotiated. If you are ready as a Chief Justice to tell us that you will negotiate what the Constitution provides, on what basis, under which section, under which article of the Constitution, under which section of the law will you do that? Remember, at one time, the CJ, the position of the JC Act, which was very clear that only one name shall be presented to the president to appoint. The executive tried to sneak in that all three names to be nominated. The courts declared that attempt unconstitutional. Therefore, the CJ who was talking that, if he lands on that, the applicant who was talking that, if he gets that position and makes that discussion, the Constitutional Court, still based in Nairobi, will declare that decision unconstitutional. You cannot run the country using your own realistic approaches. You run this country based on the document given to you by Wanjiku.
All right, and finally, one last question, Wakili, because of the interest of time. I also gathered of the legal philosophy and philosophies that the learned friends have adopted or use as in their line of duty. Of course, the applicant today is sounding more of a pragmatist. They are the naturalists. But my question is pegged on the legal philosophy. Does it have any influence when it comes to jurisprudence?
Well, I teach Catholic University and I teach jurisprudence at the Catholic University. Kenyan's jurisprudence is the science of law. People have been talking about these things so that let Kenyans understand. What is the science of law? So that the science of law is made up of different schools. Different schools have different perceptions. The naturalists put God at there and the deity at the center of everything. The positivists will tell you, we don't care. If the law is the law, we follow the law. The realists, who are judges, the American judges, for example, Oliver Wendell, Cardoso, and the others, those people are telling you that we are the law. Listen to once we listen to a case, we make a decision. They do not follow presidents. And that's what the judge was telling you, that let us throw presidents, let every judge listen so that we decide cases according to the circumstances that you hear. That school of thought will cause chaos, because if there is no uniformity, if you get Justice Chitembo in Mombasa, who thinks that way, you get Justice Omari in Nyamira, who thinks differently, are we going to go shopping? Are litigants going to say, this guy's philosophy agrees with me? All those philosophies have been condensed into the laws. You either follow the law as it is, or you go to your own country and create your own law.
All right, Dunstan Omari is a lawyer. Thank you, Wakili, for making time for us tonight on the county's television.
Thank you very much.
Well, keep talking to us. The conversation continues online. The hashtag to use is Pundits Night. And that brings us to the end of tonight's edition, where we were looking at the state of the judiciary. Of course, the interviews starting today, in as far as the replacement of the retired Chief Justice David Maraga is concerned. 10 shortlisted applicants, 1 already, of course, through the interview, 9 remaining, and you can trust the county's television to be covering that live for you from today onwards to the end, till that determination is made. And that brings us to the end. I am Abu Bakr Abdullahi. Thanks for watching.